first case, or the next case is State v. Parker. Each party will have 15 minutes to present their argument. Appellant, you may reserve up to 5 minutes for rebuttal. How long would you like to reserve?
5 minutes, please.
All right. I will try to let you know with about 1 minute left in your time that you're getting close to your rebuttal. The arguments are being recorded, so when you come up to the podium, number one, please keep your voice up so we can hear you well and the recording can hear you. And also remain behind the podium because if you move around, you lose you on the podium. You should not use the name of children, minors, and any victims during your argument other than refer to them by initials or the child or the victim or some generic term like that. We have read your briefs in this case. We're ready to proceed when you are.
Good morning, Your Honor. May it please the court. I am here today arguing on behalf of Mr. Parker. This was a OVI case that was tried in the Medina Municipal Court. Several different assignments of error. I'll start with the first assignment of error, which is kind of twofold. I incorporated additional arguments into that regarding the ability to present a defense. However, what we're looking at here is whether or not the trial court abused its discretion in denying the appellant an opportunity to file a motion to suppress in this case. This court has heard this issue several times. One of the things I think it's important to note, just the time frame, I know that you've read our briefs, there was as being aware of the criminal rules, 35 days from arraignment, 7 days before trial, whichever is sooner is the deadline for filing those pretrial motions. The appellant in this case filed leave to file it outside of those time requirements when it became evident that they wouldn't be able to comply just based on the lack of full discovery. And that's not uncommon. A lot of times there are outstanding discovery issues. Videos primarily are the major cause in the delay. And so without having all the video evidence, there wouldn't be a basis to file, and that's what's needed. So there was leave sought in this case to file outside of the normal guidelines here. Unfortunately, the judgment entry from the court indicating that it was granted with the deadline was not received by the appellant, and so by the time the motion to suppress was actually filed in the case, it was filed outside of the timeline that was provided by the court.
But counsel, it was on the docket, right?
It was on the docket. Correct. So what had happened from there, a motion for reconsideration was filed. Within that motion, the additional timelines were given. I believe the discovery wasn't received until the 11th of October. The motion to suppress was essentially filed on the 8th. There were issues with the fax filing with the clerk's office. It didn't actually get docketed until the 9th. And then that's the time when the court denied the motion as untimely.
Is there a trial date set already?
At that time, I don't recall. There probably was. It's not uncommon for this court to schedule trial dates. I just don't recall off the top of my head whether or not there was a trial date set or not. But also the motion for reconsideration, appellant had put forth the information about not receiving notice of the deadline. And one of the things that I believe we noted in the brief was that the appellant in this case essentially sought 30 days to file a motion, and when you look at the timing, did file within 30 days of receiving the discovery. So the court is looking at whether or not it's an abuse of discretion for the trial court to overrule that motion as untimely. One of the cases that we cited was the minor case, and I know it's a little bit different because that case, the appellant in that case actually missed the first deadline to ask for leave, and then it walked through the additional issues with discovery, the deadline passing by the time discovery was fully conducted or completed, and the court there found an abuse of discretion in denying that motion to suppress to be filed. So the argument we're presenting to this court today is it should look at it similarly. Yes, it was outside of the deadline provided by the court. The appellant provided reasons for missing that deadline. They didn't receive notice of the deadline. And when we're looking at the reasonableness or the abuse of discretion, we're looking, is it unreasonable? Is the ruling unreasonable? Is it arbitrary? Is it unconscionable? It doesn't have to be all three of those things. It only has to be one of those things. And I think the fact that the appellant in this case sought leave before the deadline demonstrates that the court was well aware that that was the intention, that a motion to suppress was intended to be filed in the case. Obviously, because the motion wasn't filed within the deadline, it didn't get to be heard, which then segues into additional arguments we made in the brief regarding the ability to present the defense. We've essentially put those combine them into one argument because they go hand in hand. One of the things that wasn't argued or didn't get to be argued through that motion to suppress was the admissibility of the breath test in this case. There was some question in cross-examination regarding a prior breath test at trial, specifically about RFI, that's the radio frequency interference. One of the things that was testified to by the officer on the breath test, didn't even know what RFI was, just knew that it was an error. One of the things that came out on cross-examination is that, yes, there was that RFI test. Nothing in the room changed between that test and the subsequent test. And so the question really is then how do we have radio interference, but then we don't have radio interference when nothing has changed? So those are things, obviously a jury's not going to make that determination. That is a admissibility issue, not a credibility issue. And had the court allowed the appellant in this case to present that type of argument in a motion to suppress, then obviously the breath test could have not been admissible. And then that changes, and again, that's the argument of why we're saying that the ability to prevent a defense was hindered by the denial of that motion to suppress.
So you requested 30 days after completion of discovery to.
I believe the motion said upon review, which I probably would have written it differently, but it's not uncommon. I frequently just personally ask for 30 days, and I don't think that's an unreasonable request. The rule is 35 days from arraignment. In a perfect world, you show up to arraignment, you get all your discovery, you have 35 days to get things together and filed.
So the motion was upon review of discovery, 30 extra days.
Correct.
But the court just gave you a hard deadline.
There was, yes, the judgment entry, I believe, which I don't recall the date off the top of my head, but I think it was the deadline to file the motion was, I think, 13 days after the discovery was actually received by the appellant.
So did the trial court order consider whether discovery was received or not?
I
Or
don't-
gave the deadline.
No, I don't, I believe the court so the motion for leave was filed, the court gave a deadline. I don't believe there was any consideration for when and how the discovery was actually obtained. And, this is a case where the state of Ohio, I know in their brief indicated, hey, we sent you discovery, we said this discovery is available. They don't actually provide you a copy of it, you have to send them something and get it back, and a lot of it, the mail is slow sometimes. And so it's just the delay in getting discovery. I think it would be easier if everything was electronic, and I know there's a lot of other jurisdictions that are moving towards that electronic drop box, so you get it immediately, and there isn't that delay.
So counsel, just so I am clear, given the language that was in the motion, I think it was after discovery has been reviewed, right? So what was the expectation that it was that the council would just let them know when it's happened, and what was the expectation of council, that they assumed that the judge just agreed?
And that's a good question. I can't speak for what's in anyone's mind. Like I said, if I had written the request for leave, I probably would have been a little more elaborate on what I was looking for, because when I file a motion for leave, I'm asking for, it's like I said, not a common additional 30 days upon receipt, because that gives me time. We're all practicing law. We know that we can't just drop everything sometimes. We have trial dates that come up. We have cases that are set. So it's not unreasonable to need some additional time once you get your hands on the discovery.
But is it unreasonable for a judge to run their docket and?
No, absolutely not. I'm not suggesting that it's unreasonable for the court to set deadlines. In this case, and like I said, the circumstances I think that are a little bit different is the court was well aware that this was the intent by the filing. So there's the 35-day deadline. We know it's coming. We know we're not going to make it, hey judge, we need more time. So I think that puts the court on notice of what your intentions are in filing. And again, we're talking about a ruling. The motion to suppress was filed. There were legitimate grounds in that motion that could have been heard at a hearing. So is it unreasonable? What's the harm there? So you missed the deadline by however many days. What's the harm in hearing the motion? Because one, judicial economy, maybe it eliminates the need for a trial at all.
And motions to suppress are special, correct? Because they have to be alleged with specificity and facts, or else they get dismissed.
Absolutely. And so when you put forth legitimate issues and raise legitimate issues in that motion, and the judge could review the motion. I would assume the judge in this case looked at it before he just said too bad, so sad, missed the deadline. I would hope he did.
You had about 45 seconds left, by the way.
Oh, thank you.
You're welcome.
So that, I guess that's kind of what I'm getting at, is that when you present arguments that are legitimate in that motion to suppress, regardless of missing the deadline, the court does have the ability to give you the opportunity to hear that motion, regardless of the fact that you missed the deadline. And so when we're saying, is this decision to dismiss it because it was untimely, is that an abuse of discretion? Is it unreasonable? Unreasonable, just our common day definition is not guided or based on good sense. If you have legitimate issues, why not hear those issues prior to trial? Thank you.
We'll have you a full 5 minutes for rebuttal.
Good morning. May it please the court, my name is Robert Campbell, prosecutor for the city of Medina, and I'm here on behalf of the state of Ohio. Ultimately, I suppose this case is about whether the judge of the Medina Municipal Court gets to control his docket or not. In this case, the not guilty plea was entered on August 30th of 2023. On August 31st of 2023, the defendant received through email paper discovery in this case, which would be a complete copy of the police report, which includes a full narrative of the officer explaining how he conducted the tests, what he observed, what people told him, a full narrative. It also contained a copy of the breath testing results, and as with every discovery demand or request answer that is sent from the state of Ohio and the Medina City Law Department, it advised the defendant that there was video evidence, body and dash cam, and our office gets video from several different ways from different departments that we have to manage. Some, it's very easy, we can send a link, and they click on the link, they go to a site called WatchGuard, and they click on the link, and there they go, they have the evidence. Unfortunately, this police department does not participate in the WatchGuard, at least at the time. So what would happen is there was rather large video files that would have to be submitted to the defendant to contain those videos. So on August 30th, the defendant was notified, look, we've got video here, you need to send us a flash drive. Send us a flash drive, we will put the video on the flash drive, and we will send it back to you. That notice was given to Mr. Parker on August 30th. On, I believe, August 4th, at 4:26, August 4th was the 35th day after Mr. Parker's arraignment. At 4:26 p.m. that day, Parker requested a leave to plead for an additional 30 days after review of discovery. And of course, the judge of the Medina Municipal Court cannot grant leave to 30 days after review of the discovery, because who knows if the discovery would ever be reviewed, or how would we determine that date.
But he could make an order saying after the completion of discovery.
He could. That's not what they requested. And Judge Werner decided, I'm going to set a set date. I'm going to set this day as your new date for motions to happen. Now, although the defendant was informed that on August 31st that we needed to have a flash drive from him to get the evidence, the video evidence, that was not received until late in September. There were September 29th, so 29 days after Parker was told, there's video here, get us a flash drive. 29 days later, that flash drive arrived at the state of Ohio. So for 29 days, Mr. Parker did nothing to try to gather the evidence that he claims is essential. Now look, it's a DUI case. The issues on motions to suppress are almost always the same. Was there probable cause to arrest? Was there reasonable articulable suspicion for the stop? Were the field sobriety tests done in accordance with substantial compliance with the NHTSA manuals? Was there something wrong with the breath testing device?
But if you just put that in a motion, just the law, without connecting facts, then it's not even, the
Well,
court could choose not to hear it because
it
it's not
could.
specific enough. We have lots of case law in the Ninth District about that.
if, I've never seen Judge Werner deny a motion to suppress because the defendant said the field sobriety tests were not performed with accordance to the NHTSA standards. I've never seen that. But in fact, what Judge Werner did was he said, okay, look, here you, oh, and by the way, 29 days it took them to send us the flash drive. They received the flash drive, or the flash drive was returned to them, I shouldn't say when it was received, on October 11th. Okay, so, and that was over a weekend, if you look at the days, but, so roughly 12 days after requesting the video, they had the video, and they had the video 13 days prior to the date that Judge Werner had set for the filing of the motion.
All the information you're telling me now, Judge Werner didn't have that information before him when he set his date certain for the.
He did not. And if he set a date certain, just like 35 days after Raymond is a date certain. So the date certain came, and defendant could have done one of three things. One, he could have filed a motion to suppress. Two, he could have filed a motion for another extension of time, explaining all of this problems that he claims he had, or he could have chosen to do nothing. And he chose to do nothing. Okay, the excuse that they did not get notice of that hearing, or of that date, Judge Werner docketed the granting of the leave to plead the day after the motion was filed. So the motion was filed at 4/26 on the 35th day. The next day, Judge Werner granted an extension of time. So at some point, Criminal Rule 12 has to mean something. There's a reason that we decided 35 days after the date of arraignment was the date for these motions. There's a reason that's been the date for at least as long as I've been practicing law, which is 30 years. And Judge Werner holds people to the dates that he set. I know that defense counsel doesn't like that. Defense counsel does not like a judge that says, here's what I say and I mean it. So what we haven't heard in this appeal is any discussion of abuse of discretion. I mean, we used that, the word was used. But look, where's the perversity of will? That's the definition. There's no perversity of will. There's not even been mentioned. It's not suggested. There was not suggestion that he made this decision based on passion, that he was angry or prejudice, that he was partial to one side or the other, or moral delinquency. There's not been any suggestion by Mr. Parker that that's why the judge made his decision. They just don't agree with it. And with all due respect, the law clearly says it's not up to this court and this panel to say, well, you know what, I'd be a little more lenient than Judge Werner is on these deadlines. It's an abuse of discretion. You have to find that he was acting outside of the bounds of any type of law when he was acting squarely within the rules.
Couldn't it be argued that a
setting an arbitrary deadline without knowing what's going on in discovery
Well,
is arbitrary?
No, I would not argue that. I would think that if there was a problem with the discovery, the defendant would raise that issue, put it before Judge Werner, and say, Judge, look, this isn't difficult. I used to do this on a paper calendar, and I'd get assigned a case, and I'd enter a not guilty plea, and then I'd count 5 weeks, and I'd write on there, Parker motion to suppress due. And if I couldn't, I'd either file that motion to suppress, or if I couldn't because I needed information, I'd file something with the court and say, court, I really want to do this, I know it's due, but I can't do it because I'm missing this. Not an amorphous, oh, we haven't reviewed discovery or anything else. And I really don't envision, and I have not seen, when somebody comes and says, here's my legitimate reason, Judge Werner to refuse to extend the time. Once you've missed the deadline, once you've gone past that date, he's a tough guy. But if you, to use a colloquialism, come correct and say, I acknowledge this is my deadline, I need some more time, he's gonna grant it. He does it all the time. But he's also got probably 1,500 DUI cases a year that he's gotta manage on his docket. And that's something that he is allowed to take into consideration as well in managing his docket, that he's got to move these cases along. To your question earlier, I believe it was you, Your Honor, there was not a trial date set when there's a not guilty plea and a waiver of time. The judge sets it on a pre-trial course. So usually there aren't many trial dates set in Medina Municipal Court. You might have several pre-trials beforehand, but by the time you get a trial date, you've gone through all this process. You've weeded everything out. You've run your motions to suppress. Excuse me. You've done whatever argument negotiation that you can, and you're at the point where it's now or never when a trial date is set. So there was no trial date set in this case until after the denial of the motion to suppress.
Counsel, can you speak to the assignment of error too?
Yes, Your Honor. This case it was an OVI case. Mr. Parker was drinking at Bunker Hill Golf Course. He got into his car. The driveway that he exited was roughly 150 feet away from a stoplight. He made a right turn and drove directly into the back of a car sitting at the stoplight. Those folks called the police. The police arrived. Cars were still in an intersection, kind of a busy intersection, so we had cars moved off the road and approached the vehicle and began to just talk with Mr. Parker. He said he immediately smelled an almost overwhelming odor of an alcoholic beverage. Mr. Parker had indicated he had consumed 6 beers earlier, and he ran through field sobriety tests. So he was 6 out of 6 on the horizontal gaze and stagnance test. Stepped off the line several times during the walk and turn, and was also, I believe, might have raised his arms, and then did very poorly on the one leg stand. He was taken back to the Ohio State Highway Patrol post. This was a Medina Township arrest. I don't believe they have a intoxilizer machine, so he went to the Ohio State Highway Patrol post. There he was offered a breath test, which he accepted, and he tested. The report gives you 2 tests, and the lower of the 2 BAC numbers is the one that is considered to be the one that would trigger a per se a violation, and he was 0.119 on one test, 0.111
He had 3
on
tests
the other.
though, didn't he?
Not really. What happened on the first time, and again, this would be in the record but for Mr. Parker's nonfeasance on this, but the intoxilizer machine, everything is self-contained. So if there's any kind of problem with the machine just shuts down. So at some point in time, on the first test, there was some radio interference. That can happen by a officer if she's wearing a clip-on radio. If you bump that and it clicks, and if there's radio interference, the machine shuts off. So what happened was, and the Intoxilizer runs 2 tests. So the first test on Mr. Parker was run. He came back at .126. That test was fine, all right? There was no radio interference in that test. Then it ran the second test, and during the second test, a radio clicked somewhere and the machine shut down. So we did not have a valid test there. We had 1, okay, but in order to admit it, we need 2. So we had a .126, machine shut down. So we got to start the process over again, which is what happened. Ran the process over again. This time there was no radio interference. After the wait, he was now down to .119 and .111.
Cuts, I note you are now out of time.
Thank you, Your Honor. State of Ohio would request that the court affirm the conviction. Thank you.
Thank you. And again, you have your full 5 minutes for rebuttal. when you're
Thank
ready.
you. Thank you again. I guess I don't want to bounce back and forth here. Criminal Rule 16 is obviously a rule that mandates the state of Ohio to provide discovery. If we're talking about compliance with the rule, if you have a video, you should send it to me. I shouldn't have an obligation to give you something to get something in return. Maybe you send it to me, I send it back when I'm done. I think that would probably clean up the issue of the state of Ohio having evidence and there being a delay in the receipt of evidence. Just a suggestion that I have, but again, I don't make those rules. But I think that would probably clear up the issues with obtaining video evidence in cases where it's evident that it's not something that we could get easily. Just to segue off of that, the state of Ohio stood before you and said, Mr. Parker should have done something. Well, he did do something. He said, hey, I don't have this, I need more time. In the motion for reconsideration, I said, I see this entry now, I absolutely did not receive this entry, so I did not know of this deadline. So wouldn't have filed something additional with the court had they received it and still didn't have discovery. More likely than not would have said, hey judge, need more time. I think the fact here is that didn't know of the deadline, so can't file something additional to help clarify those issues and to clear that up. And I think that's significant. And that's kind of when we're looking at the minor case, which I know I talked about previously, it's a little bit different because that deadline had already come and gone by the time the request was even made. And so here, and the court in that case found it was an abuse of discretion to not allow that motion to suppress. And so I know that the state of Ohio, I think they cited too as the Jenny case, it was that case where the state is talking about, is this perversity at will, is it based on passion? Is there some sort of other issue that the trial court is exhibiting and denying the motion? I'll just note that that case was a review of, I think it was a medical board's decision revoking someone's license. But what we're talking about here, the minor case, all of those factors that the state of Ohio wants you to consider, I can tell you there's no mention of that in this court's ruling on whether or not there was an abuse of discretion in the minor case. We're looking at, is the decision unreasonable, arbitrary, or unconscionable? And as I indicated previously, we don't need all 3. Just looking at basic definitions, was the decision to deny this based on good sense? I would submit to this court it was not. There was an appellate who said, hey, I know I have this deadline, I need more time because I don't have everything I need. Yes, I agree that motions to suppress on OVI cases have a lot of the same different challenges. You're raising whether or not, can I remove this person from the car? Were these field tests conducted in substantial compliance with the NHTSA manual? Do we have issues with the breath test? So absolutely, you probably know going in the things that you're probably going to argue, but you still need to have all the discovery so you can convey those arguments to the court. And I think, I can't tell you that I've had a single police report that mirrors exactly what I see on videos. More often than not, we'll have somebody say, oh, his speech was slurred, and then you watch a video and you say, this person's speaking perfectly fine. Where is this information coming from? And then I'll kind of segue into, I know you'd asked some questions about the manifest weight argument that we made in our brief, and I think that's important too, because some of the things that the officer was testifying to on direct examination and then cross-examination completely contradicted himself. Just as an example, I know the state had mentioned the walk and turn test specifically, he stepped offline. On cross-examination, he admitted, I don't know that I actually saw him step offline. Same thing with the odor of alcohol. He testified, oh, it was an overwhelming odor, it was strong. Nowhere in his report. He admitted that on cross-examination, he didn't write it in his report. And he also admitted if he didn't write it in his report, he probably didn't observe it. So when we're talking about this manifest weight argument, we have lots of contradicting evidence between just the direct examination and the cross-examination, which is why we put forth that argument to this court, that when you look at the totality of the circumstances, the conviction was against the manifest weight of the evidence. But again, I think more importantly, the denial of the opportunity to raise the legitimate challenges that were present in the pretrial motion to suppress essentially hindered the entire case. I don't think it would have been unreasonable for the court to allow that to be granted or at least a hearing, not who knows what the court would have done at the suppression hearing, but at least given the opportunity to hear those legitimate arguments at a suppression hearing. I didn't know the answer, but learned that the trial was not set. So it's not as if we're running up on a deadline that, oh, this trial is set next week and we don't have time to get this motion in. There was absolutely an opportunity to hear it. The court should have heard it. I would just ask the court at this time to find that it was an abuse of discretion, that the suppression hearing should have been conducted, remand this case so that a hearing can be conducted on the merits of that motion, and that's what we're asking for the court at this time. If there are no further questions, I will rest on the arguments in the brief.
Thank you.
Thank you.
And thank you both for your presentations. The court will take the matter under advisement and will issue a decision in due course. The clerk of court will mail a copy of that decision to you when our decision is released. You also go to the Supreme Court website where the decision will also be released at that point as well. Thank you both.
Thank you.